Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3058, United States of America versus Keith B. McGill, appellant. Ms. Hughes for the appellant, Ms. Kelly for the appellee.
Thank you. Before we start, I would just like to take a moment to remember Ken Starr, who passed away yesterday. He was a former judge on this circuit from 1983 to 1989. He was a beloved colleague and friend to many in this building. And our thoughts are with his wife, Alice, and with his family and friends. Thank you.
Good morning. When the court sentences a defendant, the court's supposed to impose a sentence sufficient but not greater than necessary to comply with the purposes set forth in 355(3)(a)(2). That is just punishment, deterrence, protection of the public, and rehabilitation. Mr. McGill contends the sentence he was given was far greater than necessary to achieve those purposes. There's two concepts that keep appearing throughout Mr. McGill's case. One is discretion, the other is rehabilitation. And they're both, each is problematic in its own way. At sentencing, the district court chose to give very little weight to Mr. McGill's rather extraordinary record of rehabilitation. And when I say rehabilitation has a problem, this is actually what I'm thinking of. Mr. McGill, during his 20 years of incarceration, has had almost no disciplinary actions at all, no physical involvement, fighting, nothing like that. All he's done is improve himself. In fact, for the facility where he was offered a job to work in the law library to help other inmates. With their legal research. He's also enrolled in an online university in California. This is all considered under rehabilitation. But I would just like to make one point. I'm not entirely sure this is rehabilitation. Rehabilitation is when there was something wrong and you took steps to improve it. I would argue that Mr. McGill's conduct, as shown by all the records during his incarceration, are not rehabilitation. They simply show the true nature of the man. They were there already. And he continues to behave in that way. Now, one problem.
Ms. Hughes, even accepting that account, can you maybe focus on where the district court abused its discretion in its decision below?
Yes. District court abused its discretion by not giving sufficient weight to Mr. McGill's rehabilitation. And moreover, the district court during sentencing said he was relying upon a denial memo he had written when he denied Mr. McGill's motion for compassionate release. And throughout, the government basically took long passages from the denial memo and incorporated it into its sentencing memos. Here's the problem. Yes, you look at the same factors. However, in a consideration of a motion for compassionate release, the court is assessing whether or not the defendant should be released immediately, right then, that day. And in Mr. McGill's case, that would have meant a 19-year sentence. And the court said that's not enough. When sentencing at the resentencing, there was a whole array of options as far as sentences. It wasn't just right now and 19 years or back you go. It was an opportunity to correct what we felt were errors in the original sentencing. And so in doing so, the analysis of the 355(3)(a) factors is done for a different purpose. Most motions for compassionate release, there's really a focus on, is someone a danger to the community? Because they'd be letting something back in. The other factors aren't stressed. And in Mr. McGill's case, the court did not said he did not reassess the factors. He simply relied upon them as he had looked at them for compassionate release. We'd say that is an abuse of discretion. He should have done it again.
So what exactly is his sentence at the moment?
At the moment, 2 life sentences on counts, well, life on the drug conspiracy, life on the RICO conspiracy, 120 months on the violent act in aid of RICO, and 200.
These are all concurrent.
Yes, 240 months on witness tampering. And then the 6th count, which is not concurrent, is consecutive, is the 120 months for the fire.
Is he subject to the parole commission?
I'm sorry, I don't know.
You don't know.
What?
Well, when the District of Columbia had indeterminate sentences, and in 1999, according to the government anyway, they had an indeterminate sentencing scheme before the District of Columbia adopted the guidelines. And so his sentence on count 3 was, 30 years to life, which implies at least that somebody's got to decide where in between 30 years to life he falls. And I have assumed, although I don't see it in the papers, that he's subject to the parole commission in making that determination. And I'm wondering whether he has ever sought parole.
Well, actually, we did. We're asking this court to.
No, not this court, the parole commission.
No, because it was never supposed to be 30 years to life anyway. That was incorrect.
What about on the other sentences? Has he ever sought parole on them?
No, he's not. He's not subject to parole commission. Mr. McGill would argue that the harshness of the sentences, basically he traded in 4 life sentences for 2 life sentences, which is a small consolation to him. Notwithstanding that Mr. McGill went through the same procedures, looking at the guidelines, and felt that with an offense level of 34 and criminal history of 5, it would be 235 to 293 months, and requested at the lower end 240 months, which would be 20 years. That's a substantial sentence. The government did the same calculations and came up with a level 36, criminal history 5, which would be a sentence of 292 to 365 months, and requested a sentence on the high end, which was 34 years. So not even the government was asking for a life sentence.
Ms. Hughes, I see your time is up. And if my colleagues have any questions, we'll give you some time for rebuttal.
Morning, Your Honors. May it please the court. Catherine Kelly on behalf of the United States. Your Honors, in this case, the court did properly and reasonably sentence Mr. McGill as it did in August of 2021. As Mr. McGill's counsel has just said, the court did look at things such as the protection of the public, the need for looking at his prior criminal history, looking at the crimes he committed, looking at the nature of Mr. McGill's history and characteristics, and as well weighed Mr. McGill's rehabilitation in prison. In fact, at the sentencing hearing, Mr. McGill spoke, and thereafter, in explaining its sentence, the court mentioned that it was agreeing that Mr. McGill had properly mentioned his rehabilitation to the court, that it was correct for him to bring it up. The court's ultimate determination was that rehabilitation, while the court considered it, was not determinative, did not give it determinative weight, which the court was permitted to do in reasonably applying a sentence. The court applied an in-guideline sentence, which is given a rebuttable presumption of reasonableness. The court validly explained its 3553A factor rationale in the decision it made in the compassionate release motion, but made clear at the resentencing hearing that it was reevaluating that decision as of the date of sentencing, and that it acknowledged that it needed to look at that decision as of the sentencing date. And in fact, it agreed with its rationale in the compassionate release decision as of the date of sentencing.
Ms. Kelly?
Yes, Your Honor.
I have a question about your suggested remand on count 3. I read Wren to possibly say we have the authority to do that, even though count 3's sentence was affirmed in the appeal that was here last time. Guess my first question is, where do you think Wren got that authority? It seems like Rule 52 merely defines plain error rather than instructs courts on when it applies. So obviously we're bound by Wren, but why was it right?
They cited, as Your Honor pointed out, Rule 52, but I believe that the court should have authority as just a prudential matter if it sees an illegal sentence that was outside the bounds of the applicable statute at the time of the offense in this case.
But prudential concerns don't often control jurisdiction, and if we affirmed the first sentence, we did not remand it to the district court. How was it an open question for the district court? And if it wasn't an open question for the district court, how could we find error with the district court's failure to do what it didn't have the authority to do?
I believe at the resentencing, the district court indicated that it did not believe under Rule 52 that it could touch something that this court had not addressed before. My recollection of the direct appeal decision is that nobody raised an issue as to count 3 sentence. So it wasn't a matter of this court deciding in the original direct appeal that.
I think that means we affirmed it, though.
I'm sorry, Your Honor.
I think that means we affirmed it if the sentence wasn't challenged on appeal, and then when the appeal is over, I think it was affirmed. But let me ask my second question, which I think is maybe what I'm struggling with even more, which is, let's say plain error test applies. We have to find the kind of violation of substantial justice that it would take in order to find plain error and remand for a resentence on count 3. Our cases talk about there being a violation of substantial justice when it means a defendant will be in prison longer than he would otherwise be. And we have the in real sealed case from, I think, 2009 that talks about that. Here, it's a little different because even if we remand on count 3 for the sentence to be 15 years to life, as you suggest, he still has the other life sentences.
Right.
So since if we affirm on the other counts, and that would mean he'll be serving life sentences, regardless of whether we remand on count 3. So why does substantial justice require us to remand on count 3?
Because each count is individually sentenced, and even though counts 1 and 2 will provide a life sentence in this case, so practically he is not getting out, and he already hasn't gotten out in 15 years, frankly. It's important that the sentences individually be legally accurate.
And our precedents say it's important that they be accurate so that no defendant spends a day longer in prison than he should. Here, though, why is it important?
It may, that the fourth prong of a line of the fairness and integrity of the judicial proceedings, I believe, would probably be the most at point on that. And I honestly don't believe that, of course, doesn't require the court to do a full resentencing or anything else. It's just a matter of correcting the low end of that count 3 sentence. So it would certainly indicate that just to show the fairness and integrity of the court that a technically illegal sentence not remain on his judgment. If the court has no other questions,
do you think that the Supreme Court's decision in Rosales-Morales requires us to find plain error here? Because if a missentencing under the guidelines, which are discretionary, is usually plain error, then here we have arguably a statutory error of sentencing, which is more serious, perhaps, than a guidelines error.
And this too is a DC code offense as well, because it's assault with intent to murder. So it's a little different than a guidelines sentence.
Right, but wouldn't the reasoning of that case apply even with more force to a statutory violation?
I don't know, Your Honor. I'm not completely familiar with the case as I stand here. The court has no further questions, we respectfully submit that the district court did not abuse its discretion in resentencing Mr. McGill, and we respectfully request that the court affirm the district court's judgment. Thank you.
Ms. Hughes, we'll give you 2 minutes for rebuttal.
As to count 3, 15 to life would be indeterminate. However, I think it would still be indeterminate, but the actual sentence was supposed to be 10 to 30, no more than 30 years, and that would have been subject to parole. If the court did re-examine 355(3)(a) factors for Mr. McGill's resentencing, it did not, there's no evidence of it on the record. Again, he simply relied upon what he had done previously. Did the court want us to address in any way the motion for reassignment?
Nothing further, then that's fine.
Pardon?
Do you have anything further?
No.
Thank you. Ms. Hughes, you were appointed by the court to represent the appellant in this case, and the court thanks you for your assistance. Thank you. Case is submitted.
Case number 21-5140, Julie A. Beberman, appellant, versus Antony J. Blinken, Secretary of State in his official capacity. Mr. Lynch for the appellant, Mr. Hare for the appellee.
Morning, Your Honors.
Morning.
Morning, everyone. Pete Lynch, counsel for the appellant, Julie Beberman, seated at the counsel table. May it please the court. Congress has expressed its intent at Joint Appendix 388 in this matter. It has been argued that suspension of separation could be viewed as prejudging the case. Nothing could be further from the truth. All our courts, at times, find it necessary to preserve the status quo, usually with an injunction during the pendency of a legal proceeding. Such action is by no means a judgment on the merits, but is only a necessary tool designed to preserve the rights of all parties until the resolution of the legal and factual questions presented. Now, interlocutory decisions of district courts falling within the ambit of the collateral order doctrine are subject to immediate judicial review. How much more so then should interim decisions of the Foreign Service Grievance Board, an administrative tribunal, be subject to that same immediate judicial review? The collateral order doctrine should apply narrowly to appeals of interim relief orders arising under the Foreign Service Act for the same reasons as this court applied it to an appeal of a reinstatement order under the Federal Mines Safety and Health Act in Cal Portland. As in Cal Portland, the three prerequisites to qualify for immediate judicial review under the collateral order doctrine are met. First, separability from the merits. Second, conclusiveness. And third, effective unreviewability. Separability. In the same way that an inch does not equal a mile, despite slight overlap between an interim decision and a decision on the merits, the two nonetheless remain separable. The Foreign Service Act has not set a standard, but in practice, the Foreign Service Grievance Board grants interim relief to tenured Foreign Service officers if it finds their claims to be non-frivolous, like a quarter inch. And it provides interim relief to non-tenured officers, such as Ms. Beberman, if their claims are found to have more than a remote possibility of prevailing on the merits.
Isn't it a reasonable likelihood of prevailing? Isn't that the standard under the board's precedents? It has to be a reasonable likelihood of prevailing?
No, I think, Your Honor, I think that is separate. That falls under the provisions for a stay, reasonable likelihood of prevailing on the merits. In terms of the Foreign Service Act, before the Foreign Service Grievance Board, as long as a non-tenured employee has more than a remote possibility of prevailing on the merits.
Can you point to me where that language occurs in the board's cases?
I believe it's referenced in Title 22, Section 4940. I believe that's the reference. So, in any event, both for tenured officers and for...
I want to back you up, if I may. On the one hand, you want to analogize the situation here to the grant or denial of a preliminary injunction, correct?
Right.
But you don't want to use the standards for whether a preliminary injunction should be issued.
Well, I think that comes...
The standards are probability of success on the merits, just as Judge Rao said. That's not the standard in other interlocutory orders, but it certainly is the standard for preliminary injunctions. So if you're going to persist in the analogy, it seems to me that it's incumbent upon you to satisfy the conditions. And I don't see any argument to that effect in your brief, or your client's brief.
Yeah, I think what we're missing one another on is the point that the district court denied the appeal, not because of a PRO merits decision or likelihood of prevailing, but because it found that it was not entitled to treatment under the collateral order doctrine. And so that is the standard, the first standard. And I would agree with you, Your Honor. Ultimately, I will demonstrate that Ms. Beberman does meet the standards for a stay. But right now, at least preliminarily, we have to show that the district court actually had jurisdiction when they declined it. They thought they did not because they didn't feel this case met the standards of the collateral order doctrine, and that it was not separable, it was not conclusive on the interim decision, and it was not effectively unreviewable. So once we get to the question that the court is asking, I think we're in complete agreement that, Your Honor, we have
You haven't sought back pay, or your client has sought back pay, is that correct?
Well, back pay is currently on the list, but it's the least of her harms because she's been well employed subsequent to her foreign service. The real problem is...
Well, another standard for a preliminary injunction is irreparable harm.
Yes.
And I could see it if the argument here was that she was entitled to be paid and wasn't. And but even then, are you familiar with Section 704 of the APA?
Yes, Your Honor.
Yeah, which says that on appeal from or a judicial review of a agency decision that all the preliminary rulings come up too. So you can
yes, and we invite
review.
That. We invite that, Your Honor. We're not asking the court to make a broad ruling here. It's a very specific ruling, and the purpose of the congressional intent quote was to demonstrate to the court the Congress's recognition of the singular type of career path that a Foreign Service officer is on, so that if they're denied interim relief, effectively they're pulled right out of their career path, and it is damaging, and it is not something that a person can recover from. And so, in addition to the lack of pay, the impact of the separation, and it's been almost 3 years now. Ms. Beberman was separated October 31st of 2019. Every day that is lost, Ms. Beberman, is lost to the public, actually. The public interest is...
So, Mr. Lynch, say we assume that the collateral order doctrine applies here. Yeah. I'm still not sure how you can demonstrate separability. Because, I mean, there is a board decision, case number 2013-049, which says that for untenured officers, they get interim relief only if they have a reasonable likelihood of attaining relief, right? So it's the criteria that the board has set out for obtaining interim relief for an untenured officer like Ms. Beberman is very much tied up with the merits. The actual standard requires a reasonable likelihood of success on the merits under the board's adjudication. So, I mean, if that's the case, how can you show separability?
Well, I think...
Because you've not made any challenge, I think, to whether the board's, prior decisions on this are invalid or contrary to law. You've not made any challenge to the board's standards.
What we're looking at, Your Honor, is whether I'm incorrect and the court is correct with regard to the remote possibility versus the likelihood of prevailing standard. Either one of those is not the final decision. It may have some overlap with the final decision, like an inch has with a mile, but it is not one and the same. They're separable. In Cal Portland, this court had said that temporary reinstatement order has no bearing on the ultimate resolution of a complaint, as the complainant's discrimination case proceeds regardless of the commission's holding on the temporary reinstatement application, and the temporary reinstatement order does not affect the merits decision. Now, that was under the Mine Safety Act.
Well, the Mine Safety Act, the statutory standard there is very different from the standard in the Foreign Service Act.
Well, in both cases, Your Honor, I would suggest to the court that the Congress has looked at the impact of potential separation, both of minors and of Foreign Service officers. And these are not the run-of-the-mill types of careers. It causes great harm, the fact that someone is separated from the service. And that is the kind of irreparable harm caused in the interim relief that we don't see has any bearing on the merits.
Assume for the moment, we're jumping ahead. I'm jumping ahead of the jurisdictional question, but assume for the moment that we have jurisdiction. What is the standard? What is your understanding of the standard that the board applies in determining whether to extend the interim relief beyond the 1 year period?
Well, my understanding, Your Honor, is that they are required to extend it to the 1 year point. And if
my question is beyond the 1 year period.
Beyond the 1 year point, if there are grievances pending, which in Ms. Beberman's case there is still.
What's the standard that the board applies in determining whether to extend the interim stay beyond 1 year? That's my question. Do you know?
Right. This falls directly under the collateral order doctrine. It's
No. What is the standard that the board applies? Do you know? If you don't know, it's fine.
my understanding, Your Honor, is that the board routinely grants extensions or interim relief beyond 1 year.
Well, here's what the statute says. It says if the board determines that beyond the 1 year period, that delay is due to the complexity of the case, the unavailability of witnesses, or circumstances beyond the control of the agency, the board, or the grievant, then the board can extend the stay. And so I guess my question is, I don't see anything that indicates that any of those factors are even present here. So the question then becomes whether the board even had authority to extend the stay beyond the 1 year period.
Well, I think, Your Honor, the record shows that if there was any delay, it was not on the part of Ms. Beberman. It was actually these interim decisions were referring to the attempting to compel production in support of the interim relief decision.
Okay.
And so there are multiple decisions that merged. I see my time is up.
Other questions? Thank you. Give you some time on rebuttal.
Good morning, and may it please the court. Christopher Hare for Appellee, the Secretary of State. The Foreign Service Act provides for judicial review of final action of the Forest Service Grievance Board, which adjudicates grievance appeals filed by Foreign Service career candidates like Ms. Beberman. Specifically, the Act provides for judicial review under the Administrative Procedure Act, which applies to final agency action. There's no dispute in this appeal that none of the Grievance Board's orders in this case are final, nor are they collateral orders subject to judicial review. First, they do not resolve important questions separate from the merits of Ms. Beberman's grievances. Rather, they constitute the board's preliminary finding that she is unlikely to succeed in her grievance appeals. Second, they're also not effectively unreviewable on appeal from a final board decision, since they do not impact rights that would be irretrievably lost in the absence of an immediate appeal.
Mr. Hare, before we get to the three-part test that is applied in the 1291 context, I have a question about 4140. Do you have that handy?
Yes, Your Honor.
So, Supreme Court and this court have applied the collateral order doctrine under statutes authorizing judicial review of final decisions or final actions. But 4140 seems more limited, and maybe more limited in a way that matters. 4140 authorizes, and I'm going to quote from it, judicial review of final action, the secretary or the board, on any grievance. So in other words, the only thing a court can review is a final action on a grievance. I'm not sure an interim relief order counts as final action on a grievance. Do you have thoughts on that?
I do, Your Honor, and I think that's, we sort of begin and end with the statute in that respect, because on the grievance seems to suggest that there aren't a number of final actions baked into any particular grievance, that there is inevitably a final action on that particular grievance appeal, and in this case.
The statute doesn't say the grievance, it says on any grievance.
Yes, Your Honor, and that I believe refers to the specific grievance appeal that's presented to the board. Here it's a little bit complicated because there are 3 different grievance appeals at issue, only one of which is still pending with the grievance board. But I believe final action on any grievance would then be, I think a reasonable interpretation of that would be the board's culmination of its review of that particular grievance.
Why is that still pending after all these years?
Yes, John, I think the simple answer to that question is that each of these grievances has involved a number of motions put forth by the grievant, in this case, Ms. Beberman. The board has been called upon to issue numerous decisions to resolve discovery disputes, to resolve motions for interim relief, temporary interim relief, which is a slight bit different. It's more of an administrative stay before the board reaches.
Is it the Caracas or the Guinea? Which one of that? These numbers, your brief jumbled up the numbers, so I don't know if you realize that.
Oh,
Pages 9 and 10. Yeah.
No, Your Honor, I apologize. The board proceeding that's still pending is the one that ends in 001, and I believe that does deal with the, if I'm not mistaken, the Caracas.
That's the one that's been decided or still pending?
No, that is the one that is still pending, Your Honor. The other two grievance appeals have reached final decisions and are the subject of other district court litigation brought by Ms. Beberman after this case was brought, and notably involve many of the same orders at issue in this case.
I think 001 was decided, and it's 2015-35 that's pending. I think you've got that back.
I apologize, Your Honor. So the proceedings that have concluded are board number 2016-036.
That's the tenure.
And 2016-001. So it's the 2015 board proceeding that is still
right.
pending.
Mr. Hare, going back to Judge Walker's statutory question, so I guess I'm wondering, given the definition of a grievance in, I guess, 22 USC 4131, why couldn't a grievance about being denied interim relief? I mean, isn't that also a separate grievance in the meaning of the statute, right? So the statute says, a grievance means any act, omission, or condition subject to the control of the secretary, which is alleged to deprive a member of the service of a right or benefit authorized by law or regulation, or which is otherwise a source of concern or dissatisfaction to the member. And why doesn't that include the request for interim relief?
Your Honor, the request for interim relief is not a separate grievance appeal or anything quite like that. It as you know, this court is very familiar with the standard that a district court may take in assessing the preliminary merits of a case. They're the same. It's the same merits, the same legal and factual issues underlying that grievance appeal. So I think it's reasonable in light of the statutory language to interpret them to be the same, and that the final action would be the culmination of the board's adjudication of any particular.
What's the board's standard for granting interim relief beyond the 1 year period?
Once the board decides, Your Honor, that it will grant interim relief, my understanding, and it is not in the record, the board's adjudication of any additional extensions beyond the statutory period, is that they would more or less be automatic. And that is once the board has decided that the
1 year period, maybe I'm under a misimpression. I thought the 1 year period was automatic, right?
So there's two stages, Your Honor. First is the temporary interim relief, and that's more or less an administrative stay. And the board would extend that as long as necessary to review the request for interim relief. And once the board has decided that interim relief is or is not warranted, then the board may extend that relief further while it adjudicates the merits of the grievance appeal.
What do you do with the statute? It's 4136(8). It talks about the board may continue to grant the interim relief if it delays a final decision, and then it gives the reasons. And my understanding is that in reading those various reasons or justifications for the board or the standards, maybe, that none of them deal with the merits of the case.
They don't. This statutory standard does not mention the merits of the case. You're correct, Your Honor. This presumes, however, that the board has already determined that such relief should be granted. So those are the additional concerns that the board must grapple with in extending beyond, and that's what I was referring to earlier, Your Honor, and I apologize for any confusion. The interim relief is time limited under the statute that the board may grant, and then the board extends that as a matter of equity, more or less, as it adjudicates the grievance to its logical conclusion.
The district court dismissed on, am I right in remembering the district court dismissed on 12B6?
Correct, Your Honor.
Do you think that this is a 12B6, or do you think that this is jurisdictional?
I think, Your Honor, this is appropriately a failure to state a claim under this court's jurisprudence regarding final agency action, the Trudeau case, I believe, whether or not agency action is final and reviewable.
Do you think we have jurisdiction? It's just that there's no claim.
Yes, sir. We have not challenged the court's jurisdiction to review this type of action, and that's because it comes up in a fundamentally different way than a preliminary injunction would, which Congress expressly provided this court with jurisdiction to review interlocutory orders. And, you know, the collateral order doctrine is I think, a practical construction of the word finality to be viewed within the construct of 12B6. I see my time is up, so if there are no additional questions, we'll rely on the arguments presented in our brief, and we ask this court to affirm the judgment below. Thank you.
Mr. Lynch, we'll give you 2 minutes.
Thanks, Your Honor. The Foreign Service Act itself does not set a standard. The Foreign Service Grievance Board, however, does say if there is a more than a remote possibility of prevailing, which is less than a preponderance, which is far less than the mile to win on the merits, then interim relief can be granted. Ms. Beberman had 3 grievances. She prevailed on 1, lost the second, and the third grievance, 2015-035, is before the Foreign Service Grievance Board right now for a final decision. Clearly, the denial or the denial of interim relief did not hold up or drive the interim decisions. They're separate from the grievance on the merits. So I think that's the crux of this matter right here. Is we can look down the race course just a slight bit, but that by no means is a judgment on the merits. On May 5th of 1973, it was a nice day in Louisville, Kentucky. 13 horses lined up for the Kentucky Derby. Secretariat was one of them. The race started. Secretariat was the very last horse out of the blocks. Every quarter mile in the 10-furlong race, which is 5 quarters, that horse set a new pace, outdistancing its previous time for the prior quarter. It passed the entire herd. It passed on the final stretch. It passed its closest competitor and won by 2.5 lengths. I think that is standard. The interim decision does not drive the decision on the merits. Thank you.
Thank you. Case is submitted.
Case number 20-1379, Center for Biological Diversity and CRCLF petitioners versus Federal Energy Regulatory Commission. Ms. Colon for the petitioners, Mr. Glover for the respondents, Mr. Nelson for the intervener.
Morning, may it please the court. This case is about what FERC admits or acknowledges is one of the largest, or the largest, liquefied natural gas facility that it's ever approved, which Chairman Glick commented poses many first-of-their-kind challenges that demand in-depth and rigorous examination. But unfortunately, FERC failed to meet even some of NEPA's most basic requirements in this case. I'd like to focus on 4 of those today. The first is the requirement that the agency consider a realistic no-action alternative.
Could you speak a little louder, please?
Sure. So as I said, the first is the no-action alternative. The second is the requirement to consider, to use generally accepted methods to consider the significance of the project's impacts here, the direct emissions. The third is the requirement to consider connected actions as part of the same environmental review. And the fourth is the requirement to take a hard look at impacts here, the impacts to Cook Inlet belugas. Turning to the requirement to consider a realistic no-action alternative, I want to cover what FERC concluded here, why it matters, and why it was arbitrary. The EIS here says that, again, this project, which is unprecedented in scale, and which, if it was built, would be one of the largest infrastructure projects ever built in the United States. If FERC declines to approve
unprecedented in scale, it's going to follow the oil pipeline from Prudhoe Bay down to Cook Inlet. It's taking the same route. So why is it unprecedented? Isn't the oil pipeline the same?
Those are actually FERC's words, so unprecedented in the term in the context of Section 3 approval. And besides the pipeline itself, which you're right is similar in length, it also includes the liquefied natural gas facilities, the compression facility, export terminal. There are many components to the project, and it may not be unprecedented in terms of the largest project ever, right? So one of the largest infrastructure projects ever built in the United States, if it is in fact built. But again, what FERC said here is that if the project is not built, or if FERC declines to approve the project, then nonetheless something similar would be built, likely, and that the likely environmental impacts would be the same.
I have to confess, I find this whole business about no action alternative to be, difficult for me to understand. Because if I were an environmental impact statement writer, I could satisfy that consideration of that prospect in one sentence. And that is, if we don't take any action, nothing's going to change, period. And so I don't understand what more an agency has to say in order to satisfy, it's not satisfying the statute, it's satisfying the CEQ regulations, which FERC, for reasons that I don't understand, adopted. But
well, to your point, it's not necessarily that they didn't say if the project isn't built, the impacts won't occur. In fact, they did say that. But the problem is that they further said, and if they don't approve the project and the impacts of this project don't occur, something nonetheless similar would likely be built. And so the problem and the kernel of the matter is that FERC's task is to weigh the environmental impacts versus the benefits of the project and make a public interest determination here. And when the agency believes that the impacts are likely to occur regardless of its action, it's going to conclude that its action doesn't matter very much, environmentally speaking. And that's exactly what the environmental impact statement here says. Given that there would likely be similar impacts regardless of what it takes, what action it takes, there's no significant environmental advantage to the no action alternative.
Ms. Cohn, isn't FERC's obligation here to look at reasonable alternatives, right? And reasonable means in light of the project's purposes. And so here there's a purpose of bringing natural gas down from northern Alaska down south. And so a true no action situation in which no pipeline was built wouldn't serve the objectives of the project.
That's true. And the issue is less, again, that FERC didn't carry the no action alternative forward and analyze it in detail, because it's true, a skeptical reader could infer what the impacts of a no action alternative would be from just assuming that the impacts described wouldn't occur. But FERC didn't say that and has never recanted the position that a similar project would likely be built regardless. And the problem with that is that it's not just a factual conclusion, which is unsupported, it's also a partially legal conclusion, because FERC is essentially prejudging that it would also approve whatever similar project would have to be built, because no similar project could be built with FERC also approving that project. The court has to be convinced that FERC understood the impact of its decision here, and that's not what the record says right now. And in fact, FERC continues to defend that position.
And in order to achieve the goal of commercializing the Northern Slope liquefied natural gas, bringing it to market, the only alternatives are comparable pipelines, right?
Well, in order to commercialize North Slope gas and export it, there are actually many different alternatives, but the only comparable alternative, or sorry, what constrains the alternative that FERC looked at here, and the reason that the impact is the pipeline across the entire state, is in part also because of the in-state interconnections. But the commercializing North Slope gas could be achieved in different ways potentially.
Okay, so thank you for that clarification. And so then, same question though, if FERC could not achieve that third purpose of interstate connections, unless it either does this project or a comparable project, right?
That's absolutely right. And we're not arguing that FERC should have adopted the no action alternative or needed to consider it.
So, but then there is a line in your reply brief that made me think that you were. So that this is, please clarify.
Oh,
the lines on page 4 of the reply, and it says, if avoiding environmental impacts warrants denial of this project, it will likely warrant denial of a comparable replacement.
That is not intending to make the argument that it should be denied. But the point is that if FERC...
Do you think it should be denied?
Well, personally, I do, but that's irrelevant to our petitioner's arguments.
Well, does the petitioner think it should be denied?
Again, petitioner's arguments are that FERC needed to understand the environmental impacts of the decision it was making, and the record here doesn't show that it does.
So the Center for Biological Diversity takes no position today on whether environmental impacts warrant denial of this project?
Well, the entire thrust of our brief is in part that FERC didn't adequately consider the environmental impact. So it would be difficult to come to a final conclusion about whether the project should be approved or not based on an analysis that's lacking. And that's part of the problem with FERC's proceeding on this inadequate record.
Is FERC, I mean, you say that there's a legal conclusion kind of tied up with that. I understand your point, but I mean, in the context of the Natural Gas Act, I mean, we've said before that the Gas Act sets out a presumption favoring authorization, right? And, that part of the purpose of the Natural Gas Act is to promote the orderly, use of natural gas and, bring it to market. So in light of those policies, is it not, is it really a legal conclusion to assume that some other pipeline would be built when there is a plentiful store of natural gas and a need for natural gas to be, brought down from the North Slope?
Well, it is, to the extent that the conclusion is that something similar would be built. In other words, one that transports the same volume, involves the same environmental impacts of exports, which is what we're found here. Because other projects could be considered and have been considered for decades about commercializing North Slope gas in other ways. And FERC itself considered and then dismissed several alternatives that would not have the same environmental impacts with completely different sets of environmental impacts. So that's the legal conclusion, but again, founded on a basis of a lack of factual support for there being any likelihood that a project that is, especially one that's on all fours with this project, environmentally speaking, would go forward. Because what we have is a history of failed proposals for the commercialized North Slope gas in different ways, featuring different environmental impacts. entirely. I'd like to turn to the requirement to use generally accepted methods to consider the significance of the project's direct emissions. This court's decision in Vecinos controls here, and FERC hasn't offered a basis to distinguish that case, aside from on the merits, aside from their exhaustion argument. I want to talk again briefly about what FERC concluded and why it matters.
Can you first address the exhaustion argument that they made? Where did CBD exhaust the argument that the regulation is, you obviously raised the social cost of carbon argument, but it seems that the regulation was only mentioned, in passing.
So the petitioners addressed that on the joint appendix, page 1555 to 58. It's 3 pages. And what petitioners argued is that sort of the substance of the argument, that FERC couldn't, responding to its comment in the order that social cost of carbon is not a universally accepted method, that FERC can't hold out for a universally accepted method, and there are other potential methods as well, and that the agency has to, in light of its environmental review obligations, consider a generally accepted method, and throw up its hands and must use best efforts. And we cited that regulation for that argument in the body of our rehearing.
You just cited 3 or 4 pages, but that kind of makes it sound like statute was alluded to, referenced, quoted even over the course of 3 or 4 pages, but the statute's never even mentioned in the text of a single sentence and is only mentioned once as a CEG site. Is that correct?
The overall context is in an argument about the statute, and the rehearing request is about FERC's failure to...
Would those 3 or 4 pages have read any differently if the statute didn't exist?
Yes.
How so?
Petitioners might have reached the same conclusion that FERC should choose a generally accepted method. That's also the requirement in the statute.
And I think I may have misspoken. Is it a statute or a reg?
Regulation.
It's the reg. So it's 1502-21C. So I'm not clear on the answer to my last question. If 21C did not exist as a reg, what substance of those 3 or 4 pages you mentioned would have read any different?
That FERC should not avoid making any determination about the significance of these massive emissions, that it has to consider at least the methods that are available there.
You don't think FERC would have needed to do that absent the reg?
The regulation implements the statute, and that's the source of the requirement. So, needed, I guess it depends on what the source of the need would be.
I guess if FERC were to appeal the reg tomorrow, and then all of this were to replay down the road in a different case, is there any part of those 3 or 4 pages that would read any different other than the absence of the CEG site?
Your Honor, I honestly don't know. I think it's difficult to speculate. That's a pretty fundamental change.
That is my point. It's not at all clear. We don't know if any of the substance of your argument in those 3 or 4 pages would have read any differently absent the reg, because the argument you're making doesn't depend on the reg and is not expressly tied to the reg.
Well, I have to respectfully disagree. We did cite to the regulation, and we're making the argument that the regulation imposes. And I believe that means that we raised the issue with specificity before the commission.
I've looked carefully at those pages that you've cited at this exhaustion question, because of course, exhaustion is jurisdictional here. And it seems that the arguments here are pretty similar to the arguments that have been raised previously about FERC's declining to use social cost of carbon, and which we have upheld in Earth reports and then cases following that. And I guess I don't know if there's specific language you can point to that shows how your argument is tied to the regulation and not to the other arguments, the sort of the usual arguments that that are made against their failure to use the social cost of carbon.
Well, as FERC mentioned in its brief, we preserve the argument in a similar way to the way that the petitioners and vecinos preserve the argument. And we did cite to the regulation in the body of the case, and made the substance of the argument, putting FERC on notice of what the legal issue was that we were raising.
Do you think vecinos is binding on this panel with respect to the exhaustion question, which it doesn't seem as though it was briefed or explicitly considered?
No, not necessarily, but in this case, I believe we preserved the argument.
Let me ask one more question along these lines in terms of similarities to whether it was preserved here relative to vecinos. This is going to sound like I'm saying it matters how many times you cite the reg. That's a lot more matters than that. But in the comments to the draft of the environmental impact statement in vecinos, the equivalent of 21C, 22B4 was mentioned 2 separate times. And then again, it was mentioned in the petition for rehearing. 3 times it's being brought to FERC's attention. And only one of those 3 is the sort of CEG, like, throwaway site. Here, all we have is 1, not 3, and the 1 is the CEG site. So why isn't this different for that? Why does that difference not matter?
Well, I don't want to tell Your Honor something that you know, but CEG site does mean that the authority stands for, the EG part honestly is a mistake, but the C part is still accurate, right? It's arguing that the regulation supports our argument, which is that FERC needed to use best efforts to analyze the significance of these. Again, the largest direct emissions impact, basically profile for a project that FERC has ever considered.
Was it mentioned was 21C or 22B4 mentioned in the comments to the draft of the environmental impact statement in this case?
Yes. I don't have
Nowhere.
the citation handy, I'm sorry.
Maybe on,
What's that?
you're going to get rebuttal?
Yes.
Maybe on rebuttal, if you could let us know.
Thank you.
Good morning. May it please the court. I'm Matthew Glover, and I represent respondent, the Federal Energy Regulatory Commission. I guess I'll start with what the court was just discussing. Contrary to the petitioner's argument, we did distinguish vecinos for a couple of reasons. I'm happy to talk about the jurisdiction because that's where you left off with vecinos, but I'm also happy to talk about why this is distinguishable on the merits. On the jurisdiction, as we said in our brief, we think a CEG citation to this regulation was not sufficient to put us on notice, particularly when they had a different part of their rehearing order talking about this regulation. As to distinguishing vecinos, the court in vecinos faulted the commission.
Can I just ask you one question? What is happening at the commission after the vecinos remand? How is FERC? Has FERC, we couldn't find anything that FERC has said in response to that remand, and I was interested to know, you could possibly tell us what the status of that is.
So it's been remanded to the commission and it's still under consideration.
Mm-hmm.
So I think my understanding, the e-library docket, there has been no further commission order post-remand.
Mm-hmm.
I can look at that and provide the court with a follow-up answer.
Has FERC elsewhere indicated, in another order or decision, how it thinks that the regulation fits with its refusal to use the social cost of carbon? Because that's sort of the question that vecinos asked. I'm wondering if it was addressed in any other order of FERC, that broader question.
Yes, it was. And before I get to that, I would just note, Judge Rao, I'm a little hard of hearing, and so I'm having a little bit of trouble hearing you.
Yes,
and I apologize that just my own physical shortcomings. the Mountain Valley Pipeline rehearing order, which we mentioned, and I have it with me if you want me to grab it. But in their reply brief, they do note that in Mountain Valley Pipeline, the rehearing order is 161 FERC 61,197, and then the paragraph numbers are the FERC internal paragraphs, not the citation. But they point to paragraph 281. But if you look at paragraph 281, where we said other agencies have used social cost of carbon, we were providing, and we incorporated it here, citing it by reference, our merits sort of determination that we don't think social cost of carbon is relevant. But, we noted in a footnote to that paragraph, footnote 769, we said, that the regulation exists. We understand the regulations there, and we think that our method of quantifying and, stating that we don't have a way of telling based on, these comparisons, if it's significant, meets the requirements of the regulation.
Okay. So you have said that.
We have said that. And then here, I would also note here, again, not as to their vecinos argument about the social cost of carbon, but we did discuss in our orders, I think it's paragraphs, we described their arguments about what was then 1502.22 in paragraphs, I think 17 to 19 of the rehearing order. And then in paragraphs 20 to 22 or 23, we give our reading of the order and why we don't think, of the regulation, and why we don't think the regulation applies here. As to their sort of statements that you can't, say that there's no available information.
Well, there's another question lurking in this and about the social cost of carbon, and that is whose estimate. The Obama administration is the first to introduce that concept, and they estimated that it was $43 a ton. Then the Trump administration came in and had scientific studies done, and they estimated it was $3 a ton. And now the Biden administration, by my calculation, has come in and said, no, it's $51 a ton. So whose social cost is the one that should prevail if you even use that idea?
So, Judge Randolph, I think you're getting at the second reason that we have rejected on the merits the social cost of carbon is that there's no clear, standard for what quantifiable number to have used. And so that's one of the reasons we've rejected it. Again, when we've rejected it, we've mentioned that other agencies think it's available for, other purposes, but we don't think, and we said this in the Mountain Valley order, we said this in the order that underlies the seniors, we said this in a number of orders, we don't think it can help us address the project-specific impacts and the significance of the the greenhouse gas emissions, and what they would impact with respect to climate change. And then we usually put, I think in the order here, we put in parentheses, things like global warming and sea level rises. So our statement is, we've quantified this. We don't think that the social cost of carbon is going to help us determine whether that quantity is somehow going to, at a project level, impact global warming or sea level rise.
Is everything you just said FERC's position still going forward in new proceedings on new matters?
A couple of points on that, Your Honor. We put out a new policy on pipeline certification, predominantly under Section 7, but would also apply to some aspects of Section 3. We revised that to be a draft, so the Commission hasn't given a final statement on this. We're still considering comments. I think we were receiving comments up to, I believe, August 28th or something like that. So the Commission has not taken a formal position on what it's going to do going forward. With respect to that, I believe there were a couple of pipeline projects under Section 7 where we did quantify the emissions and perhaps used a number and said, here's what I think I could check on this, but I believe there's one or two where we did say, like, here's what social cost of carbon would be, but we never said, and that's required to determine significance, or we never said, like, we think it is the tool. We've yet to take a final position on that, but we have repeatedly previously said it's not useful for project-specific impacts. And my understanding of the draft that we have pending is the draft states a certain amount, I think it's 100,000 tons per year, is considered a significant contribution to global warming. The draft doesn't state that you use the social cost of carbon to determine whether it's a significant component.
Let me try a statement, and then my question is going to be, does FERC need to consider this? Does FERC have the discretion to consider it? Or can FERC not consider it? Like, they have to, it's up to them, they're not allowed to. If a project isn't approved in the United States, the market need may well be met by a new project outside the United States. Would have same or similar or worse emission of the greenhouse gases that affect the planet equally no matter what country you live in. FERC should consider that, has the discretion, or is not allowed to.
So we're talking here about a Section 3 determination, not a Section 7 determination, which in Section 7 includes necessity and public interest. And so there we do have to determine whether there's a need for our project. In Section 3, and particularly, I should have highlighted this a little bit more in the brief, but Section 3 distinguishes between exports when Department of Energy is making determinations to free trade countries, which doesn't mean all free trade countries. It means a national interest provision of free trade in natural gas. But 3C, which was altered in a 1992 amendment to the Natural Gas Act, says that the Department of Energy shall approve export applications to free trade countries without revision and promptly. And so that's not subject to NEPA at all. And so stepping back to your question, the commission, first of all, not knowing like another project that's going to be built somewhere else is not foreseeable to us. But in the Section 3 context, we're not considering is this project needed for the international market of liquefied natural gas, particularly given that they already have their free trade approval. They could export the quantity that they've been approved. I think it's 2.5 BCF. The numbers are in the data, I apologize, but they could export that to free trade countries starting immediately. And so for our Section 3 analysis, that's not something we would I think that's not foreseeable, just as the kind of downstream impacts of burning the gas are not foreseeable. I think that would get us outside of public citizen and Earth reports, et cetera. If that makes sense. I'm happy to talk more about this. I just will note, Vecinos was an Administrative Procedure Act ruling. The court said, we do not hold the commission was required to address petitioners, was required to use social cost of carbon. We do hold that the commission was required to address petitioners' arguments concerning the significance of 40 CFR 1502.21c. That's at 6F4 1329. We think in the authorization order at paragraph 216, JA 1089 to 1090, we said we have neither the tools nor expertise to determine the project-related emissions. That's a merits determination. We think this looks like the Sierra Club versus Merida case in the Seventh Circuit, where we've said we have made the determination that social cost of carbon is not a valuable tool. And so it wouldn't be something that we would take under the regulation as, we should scientifically accept it. We've rejected it for purposes of the Natural Gas Act Section 3 project-specific analysis. On the no action alternative, I just want to note.
Let me ask one question before you move off that. The last question I asked to petitioner that said she was going to look into a rebuttal. Do you have an answer on that as well? And the question is, in the comments to the draft environmental impact statement, not the petition for rehearing, but the comments to the draft environmental impact statement, was the reg at issue 21C mentioned?
I believe it was mentioned with respect to similar to their earlier argument saying we needed to gather more information, but I'm not certain of that. I do want to say something quick on wetlands and something quick on segmentation, and I'll start with segmentation. On the segmentation argument, I wanted to note a case that I just didn't catch till preparing for argument, and it's a case by this court called City of Boston Delegation versus FERC 897 F3rd 241. It's a 2018 decision where we were challenged for a series of pipeline upgrades in the Northeast that we were segmenting them and they should be considered one project. And the court said that they weren't similar actions. However, we were required to consider all of them under the cumulative impacts because cumulative impacts is broader. I know I'm in the red light. And the point there is just the court has said following public citizen in Freeport and all of these other cases that for cumulative impacts analysis, we don't consider the export, the upstream and downstream emissions caused by the export because that's not part of our statutory or delegated statutory jurisdiction. And so if it's not part of the larger cumulative impacts question, it wouldn't make sense to say.
Did the Department of Energy do an environmental impact statement during the licensing proceeding?
Of the free trade exemption, absolutely not. It's exempt. They initially accepted ours as sufficient as they had done in the Sierra Club versus Department of Energy, the follow-on to Freeport. They then reopened it. That was petitioned for review to this court. I think I gave the dates and stuff in our brief. They reopened it to the supplemental environmental impact statement. The most recent status report, and I reached out to the Department of Energy, the most recent status report in that in abeyance case is that they have issued, I believe, the draft supplemental environmental impact statement. They've received comments, and I think they've put out notice of the draft final supplemental environmental impact statement, but I don't think that it certainly, I don't think has become final yet for purposes of that. And that case
you know, the reason I ask that is that if you go back to the statute, which is not a bad idea in this area, and the statute says that you have to include in every recommendation, et cetera, for major federal action affecting the environment significantly, a statement about the environmental impact. And it has to be, I can't remember the exact language, the statement by the decision maker or something to that effect. But it seems to me that if the Energy Department does an environmental impact statement and FERC can look at that, why should FERC have to duplicate that with respect to the area that is within the jurisdiction of the Department of Energy? And on vice versa, I mean, why should the Department of Energy have to do a separate environmental impact statement on the building of the pipeline? They can use FERC's.
Absolutely, Your Honor. That's what they have done in previous proceedings. That's what they did here as to the impacts of the siting, construction, and operation of the pipeline. They said, you know, they agree with ours. The court has said that you can't blindly rely on another agency's activity. You need to, you know, establish you've looked at it, you've considered it. DOE did that here. But that goes back to the Freeport Earth reports and these other cases, which note that for our purposes, and it builds off of public citizen, Department of Transportation versus public citizen, where the Supreme Court was unequivocal that the Department of Transportation sub-agency couldn't consider the president's action allowing trucks to come in from Mexico when they were doing the environmental impact of their safety regs. The court has said following that for us, meaning the commission, we don't look at the impacts of the export because we have no statutory authority over that. And so it's been placed out of our statutory authority. That's part of why the segmentation reg we don't think would overcome the statutory balance that have been drawn between Department of Energy's authorities and ours, and this court's sort of teachings coming down from public citizen. I'm over time, but I would like to just touch on a point on wetlands that's in the record that I didn't get clear at all in the brief. On wetlands, we noted that we were counting different things from the core, and that when the agencies got together, they determined that the difference was only 1%. And the biggest sort of explanation for why their statistic about 1,320 or 1,380 acre difference is not, it's a noise statistic, I would call it, is actually, if you look at the record JA 407, FERC explains that we consider 4 types of impacts to wetlands. There's temporary impacts, which are impacts that occur during the course of construction. Construction is expected to be 8 years, and that will be remediated shortly thereafter. Then there's short-term impacts, which are impacts that could last from, I think, about a year to 5 years after you start remediation. So after construction on that piece of the project. Long-term impacts, they would be remediated. It would take between 5 and 30 years after you start remediation. And permanent impacts to the commission are impacts that will exist after the life of the party or the project. So after the construction plus 30 years. So we said there's 8,227 wetland acres that are going to be impacted after construction plus 30 years. The core at JA 1677 explains that permanent for them means any discharge into waters of the United States that would be left in place for 5 years or more. That means something could be permanent for purposes of the core if it's left there for 5 years and 1 day, but construction is expected to last longer than 5 years and 1 day. So their statistic is essentially the core said that there would be this number of acres that are going to be impacted for more than 5 years or have fill left in them for more than 5 years and 1 day. And you said that there's 1,300 fewer acres that will be impacted for greater than 38 years. Those are not apples to apples comparison. And
could you say a few words? I have a couple of questions about the beluga whale.
Sure.
I don't understand. The population is estimated at 297 in Cook Inlet. And the Cook Inlet beluga whales are considered separate and endangered. But there are 200,000 is the estimate of beluga whales in the Arctic and the subarctic. 200,000. Only 297 in Cook Inlet. And the cases that you cited dealing with that, district court cases, indicate that there's been a population decline, but they don't know why. There was whaling by the Clickett and Haida tribe, I think it was, that did it. And that stopped in 1994, but the decline continued. And so I guess my question is, number one, is what does it mean to say that the Cook Inlet beluga whales are a distinct species? From everything I've found out, they're not. I mean, they're 297 out of 200,000.
Yes, Your Honor.
I don't get that, and that's not FERC's doing. That's the Department of Interior's doing in their designation for endangered species. And the second question I have is that the evaluation, as I read it, that FERC did, is that that the construction itself may well damage, adversely affect beluga whales, but it won't cause extinction. Is that a correct?
As to your
summary?
second question, yes, we found that particularly the pile driving, because it could have level A harassment, which is injury. And I would like to say a note about the level A and B pile driving versus vessel noise. But we did, yes, you're correcting your second question. We found that it would have a significant or an impact, a negative impact on beluga whales, but wouldn't threaten them. We pointed to the National Marine Fisheries Services biological opinion.
This is a general comment, and I think I can fall into it, and the parties can fall into it. And people tend to forget that the environmental impact statement is it's an eyes open. And if the impact statement said this will cause beluga whales in Cook Inlet to become extinct, you can still go forward with the project.
I think we might have Endangered Species Act.
Well, I'm talking about under the environmental impact, under NEPA. NEPA is not a statute that halts projects because of adverse impact.
Yes, and I believe we made that point in our brief citing Kleppe versus
Sierra Club.
Sierra Club. Your Honor knows that case much better than I do. And it's notable for many reasons, including perhaps the best signature block the United States has ever presented on a brief. But as to so yes, we agree that NEPA is a procedural statute. It doesn't force any result. I think there's another case the Supreme Court has said that. As to your earlier question about the beluga whales, and I apologize, I had a longer description that got cut of the brief of sort of beluga whales and their bulbous head and whatnot, but I was going to note that they are least concern is what it's called across the world. But I have this footnote at page 38. The Endangered Species Act defines species to include distinct population segments.
You say in the footnote they're genetically distinct, and I don't know what that means.
I think that they have been contained in that area, and thus, like, sort of their genetic breeding would be distinct. I'm not aware of like a physical trait that they have that others might not, as compared to say like the Sumatran rhino is genetically distinct.
I don't want to get too
black or white
into
rhinos.
this, but my understanding is they're not contained, that they're only in there for a certain period of time. They migrate in and they migrate out.
So I think I relied on that case, but I should have relied on the record where we do know that they predominantly live in there. It's not like the Cook Inlet is enclosed. And I think if you look at kind of one of the maps, and I can tell you where of their range, it appears to like sort of go. Sorry?
It's an inlet, so they can get out.
Yes, sorry. It appears they might go out a little bit, but we're not suggesting that they leave. I think looking at that opinion that I relied on, and I was amused when they criticized that, because they're right, I should have found it in the record. I just didn't find a good description in the record of where they are. The statement is they're in the upper Cook Inlet during that time of year, and they move throughout the Cook Inlet. They have different densities. But as to the stressors, they criticize us for having environmental conditions 25 and 26 that address pile driving. But if you look at it, it's in the record, we said pile driving can cause level A harm, which is injury, versus a level A harassment, that's injury, versus level B harassment, which is just disturbance causing a species to change its behavior. We said vessel noise would only cause level B harassment. So we did put more emphasis on the activity. We thought.
Sorry. I have one question about the wetlands 1,000-acre discrepancy. I know maybe there's not a 1,000-acre discrepancy, but let's say that there is. Let's say that there is a 1,000-acre discrepancy on the wetlands issue. 1,000 acres is is a significant enough fraction of, say, Manhattan, which I think is maybe in the ballpark of 14,000 acres. It's a much smaller fraction of Alaska. What are we supposed to do? Does it matter when we're looking at these questions whether the 1,000 acres is in a big state or a small state or a small city?
So I think that could depend on, you have to look at what the area being affected is. If, for example, and this is another point, they haven't identified any acres the Corps considered impacted that we said, oh, they're not going to be impacted at all. Again, the 1,000 acres is apples to oranges comparison, but the Corps had said, gee, we think this is going to impact wetlands in, Denali National Park when you do the Denali alternative. And we had said, we don't think it's going to impact the wetlands at all. And it might be a small difference, but like we would have had a disagreement with the Corps about why there would or wouldn't be any impact. Someone brought it to our attention. We should explain our reasoning. I don't think a distinction with the Corps is a reason that both agencies can be happy with their conclusion and can have reached reasonable conclusions. As Judge Randolph was getting at, NEPA is a process sort of driving statute. You're right, there are, I think interveners highlight this in their brief, 600,000 or some number of hundreds of thousands of acres of wetland in Alaska. But I would again step back and emphasize they've pointed to no wetland the Corps considered and we didn't. We explained that when we looked at the Corps' data and ours, we found less than 1% distinction in total wetlands. The problem was, and I'll fault myself for not highlighting this, if you look at the two record definitions of permanent, they're entirely different definitions.
Any further questions? Thank you.
Thank you.
Mm-hmm. We'll hear from the intervener.
May it please the court. My name is Howard Nelson, and I represent Alaska Gas Line Development Corporation, which is a public corporation of the state of Alaska. This project is extremely important to the state, and unlike most projects that come before this court, this project has the overwhelming support of the residents and businesses that will be affected by this project. The first thing I'd like to mention is petitioners emphasize that this is the largest natural gas project ever. Well, this is also the largest, at least one of the largest, if not the largest, comprehensive environmental impact statements ever performed by FERC. AGD's filed 55,000 pages in its application describing and evaluating impacts. The commission took 7 years. Its staff took 7 years from 2014.
I think the environmental impact statement for the Powder River Basin is larger.
Okay. Well, one of the most comprehensive.
Yeah.
The commission also consulted with several other agencies with subject matter expertise, like the Fisheries Service, on the issue of beluga whales, and it ended up in a 5,000-page EIS with appendices. I want to talk mostly about the indirect impacts, but I just want to briefly talk about a few of the other issues very succinctly. On the issue of the significance of direct impacts and exhaustion. We filed a 28J letter a few weeks ago informing the court of the recent Delaware River Keeper case. And I filed it with respect to the in-state gas usage. But if you look at page 12 of that opinion, the court also rejected the petitioner's reliance on vecinos and the CEQ regulation because petitioners in that case had failed to preserve the argument on rehearing. On the no action alternative, petitioner's argument is inconsistent. If you look at page 6 of their reply brief, and I think counsel said this now, they say they are not arguing that FERC erred by failing to select the no action alternative, only that it failed to evaluate it. But the assumption that it takes issue with that another project will be built, that this one's not built, is one of the reasons that FERC provided for not selecting the no action alternative. That assumption was not a reason for not evaluating the impacts. The FERC did evaluate the impacts. They did it on a resource by resource basis. With respect to wetlands, I just want to mention, if you go to JA 1754, that is where the FERC talks about the different measurements that FERC counsel was talking about for permanent and temporary.
What was that, JA what?
JA 1754.
Thank you.
And then just briefly in response, Judge Walker, to your question, I think in our brief, we responded, and it was on page 16 of our brief, we responded to petitioner's argument that that somebody in response, another party in response to the draft comments raised this regulation. And we pointed out that you have to preserve it. That party did not request rehearing. So that comment is not relevant to the exhaustion argument because it wasn't raised in rehearing.
And the petitioners before rehearing did not raise the reg with regard to social cost of carbon.
That I don't know. I just know that what they put in their brief was they referenced different parties that raised it in comments. They raised it, as you said, in one line in the
rehearing.
Yeah, and rehearing.
This does not relate directly to your argument or anybody's argument, but I'm just curious. Does Alaska still send checks to individual citizens after a certain residency every year?
I don't know the answer to that question.
We used to, because of the enormous oil revenue.
Right.
And it just occurred to me that no wonder the population is in favor of a gas pipeline. Just increase the amount of the check they get every year.
Well, whether they get a direct check or not, that Alaska's economy, is very affected by whether or not they can get this gas out of the North Slope. They've been trying to do this for some time. And I'd like to talk about the indirect impacts. And, we raised in our brief that with respect to that issue, petitioners rely on the segmentation doctrine and its application to the facts in this case on that issue. They didn't raise that issue sufficiently in their rehearing request either. The reference to segmentation and the Delaware River Keeper case is included at the end of one long footnote in an otherwise 143-page rehearing request. I'd like to talk about the indirect impacts. That argument, the segmentation argument, fails for a number of reasons, in addition to the failure to preserve. As a legal matter, we believe that argument is foreclosed by the Freeport decision and the other decisions that talk about a legally sufficient cause. Petitioner's argument is that this is that the DOE's jurisdiction over exports is a connected action, which the FERC must evaluate together. But the issue is not whether it's a connected action. The issue is whether the connection is sufficient to establish that this project is a cause of the emissions from exports. And that is exactly what Freeport decided, that there's no proximate legal cause. It's similar to the issue of reasonable foreseeability. So does the commission have a general obligation to look at connected actions? Yes, but not a connected action for which there is no legal cause established between the project and the actions, between the project and the emissions. Sorry.
Do you have any questions? I see you're out of time. So do you have any further questions?
Okay, thank you, Ron.
Thank you very much. I will give you 2 minutes for rebuttal.
Thank you very much. In the record at Joint Appendix 90 is where we raised that regulation in our comments, 1502.2.
I didn't hear you.
Sorry about that.
I want to write that down.
Joint Appendix page 90 is where we raised 1502.22 in our comments. And at Joint Appendix 1034 and paragraph 42 is where FERC responded to that argument and described it. So they'd be hard pressed to argue that we didn't preserve the issue there. I wanted to point that out too. And
you at JA 90, if I go there, I'm going to find that you raised the issue of the reg with regard to social cost of carbon.
I want to clarify, it's not just social cost of carbon. It's social cost of carbon and other available tools. But yes, that's the area.
Do you have a number?
Yeah, Joint Appendix page 90.
No. Of what the social cost of carbon per ton is?
I don't have the number. The intervener raised that the Vecinos case addressed exhaustion as well, and I want to mention that there, where the exhaustion was improper, it was because they were making the argument that the agency should use the social cost of carbon specifically. and they cited to the regulation only in a footnote in the course of arguing that that method should be adopted on its merits, which was different than the argument we made here. I'd also like to briefly address upstream downstream impacts. I heard that Freeport and other cases foreclosed the court's ability to rule that FERC should consider this as a connected action, but I want to emphasize no case this court has decided has ever considered whether export is a connected action under NEPA, and the agency and interveners don't address the criteria for connected action under the regulations. And it was important for FERC's purposes here, even within its own jurisdiction, because the rule against segmentation exists in part because if you understand the holistic impacts of a project, then you can make changes to the part of the project that you have control over. So FERC could have required mitigation, and specifically declined to here because in part it didn't have a full picture of what the emissions were and what their significance was.
Can you also just briefly address the 1,300 acres of wetland discrepancy? Can you just say specifically in what way you think FERC's explanation of that was lacking?
FERC's explanation in the
of explaining the discrepancy with the Corps' wetland calculation.
I mean, in the actual briefs and in the orders.
In the orders.
There basically there really was no explanation besides saying we looked at it and it's a small amount, and besides it doesn't change the significance. And two problems with that. Number one, the point of NEPA is to inform the public and articulate, the agency's rationale and understanding. And right now, the public is completely uninformed about which figure FERC actually believes is correct and on what basis. And the second is that my train of thought there.
Well, FERC does say that the discrepancy is due to a methodological difference or a difference in the way the Corps and FERC define wetlands. So do you think that's insufficient or that it wasn't adequately explained in their orders?
It wasn't adequately explained. That's right, because the methodology difference that was offered, as we explained in our briefs, doesn't actually explain. They said, first of all, there was a different scope of impacts, and we looked at, that scope of impacts. You subtract out the extra wetlands that the Corps considers versus FERC, and it doesn't explain all of the discrepancy. That's how we arrived at the 1,300 acres left. And the other was a difference of methodology. And as we pointed out in our briefs, there are two places in the EIS that talk about the methodology, and they both describe the methodology in the exact same way, ultimately, not on the same page, but in completely different pages of the EIS. So that in and of itself doesn't explain. And what I was going to add is that the issue is not whether the impact is significant or not. The question is, has FERC adequately analyzed and disclosed what the impacts actually are? And so it's not enough to just say, well, we went over the significance threshold, therefore we've informed the public, right? Each one of these acres matters to some people in Alaska. I also want to mention about belugas. The EIS actually specifically found that the impact from vessel noise, which is the impact that we want to focus the court on here, would be minor, not that it would be likely adverse, along the lines of what Rana was quoting from the biological assessment. That biological assessment finding is distinct from the EIS saying that the impact from vessel noise specifically would be minor. And that's the vessel noise that's going to explode when traffic from large vessels in the inlet increases by up to 42 to 74% was the figure. Thank you.
Yes, thank you very much. Case is submitted.
Stand, please. This honorable court is now adjourned until Thursday, September 15th at 9:30 a.m.